Thank you for that introduction. My name is Spencer Edgett. I'm a partner with Chapman Intrieri. We have been representing California community associations in construction defect claims for the past 30 years. I've personally been with the firm handling such claims for the past 20 years. So with that, let's go ahead and get started and talk about construction defects in the state of California. The following presentation is going to discuss in general terms construction defects in both new and older communities. We're going to talk about the types of defects, hidden versus obvious or latent or patent defects. We'll identify what constitutes a construction defect. We're going to talk about the appropriate party to bring a defect claim, whether that's the HOA or individual homeowners. We're going to discuss the statutory process for pursuing a claim for newer communities, typically referred to as the SB 800 process or the Right to Repair Act. We'll talk about some of the defenses to defect claims and things to be mindful of to protect and preserve your right to pursue a claim, and some tools to make sure that you can protect your communities from construction defects. So different types of defects. Primarily, we're talking about patent versus latent defects. Patent deficiencies are things that are obvious and readily observable. If you look here in the photograph to the left on the screen, you can see there is some ponding due to poor drainage adjacent to the base of the structure. And this is what we call a patent or obvious defect. To the right, what you see is a cross-section of a pipe that has been cut open, and on the inside, you can see some corrosion. That corrosion is not something that's readily observable without destructive testing. You actually either have to cut the pipe and remove it to look inside, or use a borescope camera inside to identify the corrosion within the pipe. So those are the two main types of deficiencies, patent and latent, that we'll be talking about. So again, latent deficiencies are hidden defects, and if these are not identified early, they can result in catastrophic damage to the structure, especially defects that are allowing water to bypass the exterior cladding and waterproofing systems and get onto the wood framing, which can rot and decay if exposed to repeated moisture. Therefore, it's critically important to identify and correct hidden defects early on to ensure the long-term performance of the building and structures and avoid significant damage and costly repairs that can occur if these deficiencies are not remedied. I'm going to go through some examples of latent defects through a photographic record of actual cases that we've handled. The existence of these hidden defects and damage can go undetected for long periods of time. In this photo, what we see is a deck and columns, support columns, clad with a stone veneer. There does not appear to be anything wrong with this assembly. When you look at the left-hand side where you see the ladder in the picture, that stone veneer looks intact, doesn't look like there's anything wrong to the naked eye. However, as you can see in the photo on the right, there was severe rot and decay of the structural wood components behind the stone veneer and building paper, which was only identified when we opened up the column to evaluate the underlying conditions. This was a severe case, and even more concerning is that at this project, the developer knew the decks were a problem and in fact had gone out and implemented repairs. Obviously, you can see in that photograph, the repairs did not fully address the problems, and there was some structural decay to the wood there. Here's another example of a latent deficiency. This is a photo from a case that we handled in San Francisco. The forensic construction consultant that we hired was actually inspecting roofs at the project when he noticed there was a slight dip at one of the elevated walkways, and that's on the left-hand side. You can see the red and yellow door and two individuals standing there kind of pointing to the middle where there's a post, and you can see a slight dip there. The concerning part about this is these elevated walkways are about 30 feet in height and were the only means of ingress and egress to the upper units. And after the consultant identified this dip, we went ahead and performed destructive testing to expose the wood beam that was holding up this elevated walkway. You can see in the right, that wood beam was entirely encapsulated in a metal cap that was painted. You could not see this wood beam unless you actually removed that metal cap. And once that was removed, you can see the support beam on the outer edge of the deck is severely decayed. significant dry rot to the point where it was a life safety issue, and we were required to erect emergency shoring to ensure that it did not fail. So again, this shows the importance of identifying hidden defects and damages, because if this was left in this condition and wasn't addressed, at some point, it would have been failed and would have been catastrophic. The next slide here is another example of a photo where the building looks fine on the left-hand side. You see a ladder, a couple of ladders there, and the stucco looks fairly pristine. But when we opened up the stucco and peeled back the building paper, what you can see here, where the yellow arrow is pointing, is a decayed beam and wet sheathing, which demonstrates water intrusion that was getting through the building exterior, bypassing the underlying waterproofing and causing damage to the wood frame structure. So how do you know if there are construction defects in your community? So identifying construction defects, the question is, when do we investigate? And we'll talk a little bit more about the statute of limitations period or the deadlines to bring a claim. You must investigate before the deadline. If you are too late and learn of defects after the deadline passes, then you're time barred, and the homeowner or the homeowners association is out of luck and is going to have to fund the repairs themselves. There's no opportunity to go after the developer or builder at that time. Routine inspections by competent professionals are important. So you should have your community looked at sort of on a routine basis by construction consultants that can identify potential areas of concern that may warrant further investigation. And in fact, the boards of an HOA have a fiduciary obligation to investigate for defects and pursue claims if necessary to avoid homeowners being responsible for the cost to repair those defects. And that duty is actually codified in the Civil Code and the Davis-Sterling Act, which provides the director duties include whether to conduct an investigation for latent defects prior to the expiration of the statute of limitations, and whether to pursue a claim against the builder if there is one. There are some conditions that are expected and are not defects. For example, normal shrinkage cracks in stucco or concrete. There's often a debate about what is normal versus the result of poor design or installation, but there is some expectation that there are shrinkage cracks that occur post-construction in stucco and concrete products, and your forensic construction consultant can identify for you whether or not you have an actual defect or if it's just normal shrinkage that's anticipated. There are other issues that can be the result of a lack of maintenance. We're going to talk about maintenance a little bit later in the presentation, but proper maintenance is critical to ensure the longevity of your project. Finally, HOAs may have warranties, or homeowners may have warranties from the builders, and some issues can and should be handled through a warranty claim process. Typically, major expensive repairs are not adequately addressed in the warranty claim process, as we'll discuss in more detail on the next slide. But the important thing is to make sure that you have professionals engaged that can look at your community, that have a background in construction, that can investigate conditions and let you know if further investigation or testing is necessary to make sure that you catch any hidden damage or defects. Some builders and or product manufacturers, for instance, window manufacturers, provide warranties for the construction or products installed. These warranty programs can be an effective way to deal with minor issues, but more extensive and costly repairs generally will not be adequately resolved as a warranty item. The warranties themselves, they're contractual, and they often will define what a defect is. The terms of the contract control, so what constitutes a defect under the warranty, may be different than what the law provides. The remedies also may be more limited. For example, the warranty may provide that if the windows leak, that you are entitled to new windows, but the cost to install those windows may be excluded from the warranty in terms of the remedies that are available. And oftentimes the product itself is less expensive than the cost of the installation. Warranties also sometimes may attempt to limit rather than expand existing rights under the law, but the rights under the law will generally ultimately control. The timelines and warranties may be shorter than what is allowed under the law. For example, you may have a 2-year warranty on your building, even though the statute of limitations may be 10 years. There also may be a conflict in terms of the third-party inspector under the warranty program, sometimes developers will have relationships with third-party inspection companies that will come out and evaluate projects in response to a warranty claim. But because they have a close relationship with the developer, they're not necessarily acting in the best interest of the homeowners association. They're trying to just ensure that the warranty program is available, and warranty items are addressed, but typically not as extensively as they should be. Thorough destructive testing, as a result, is expensive, and warranties are generally more reactive to a complaint and not proactively investigating for deficiencies. So again, this goes back to the issue of a third-party inspector hired by your developer that has a relationship with your developer isn't necessarily going to go out to your community and look for hidden defects. They're going to respond and react to complaints that you make under the warranty. Finally, the repairs under the warranty may be limited, or sometimes they're Band-Aid repairs that are not proper for a long-term solution for the particular deficiency being addressed. So the most important thing in all of this is to have your own independent forensic construction consultant evaluate deficiencies and not just rely on the builder's warranty program. When investigating the defects, you should hire a consultant, someone that is looking out for your best interests. Consider retaining defect counsel to hire the consultant. The reason for that is if your attorney hires the consultant, then any of the findings or the reports that are prepared in that process can be protected. There may be reasons in the future that a particular report or expert will not be helpful to your position. And if the attorney controls the investigation, the findings in the report can be protected from disclosure by what's called the attorney work product doctrine. The attorney work product doctrine is a privilege, and similar to the attorney-client privilege, where communications between attorneys and their clients can't be discoverable. Attorney work product also is not discoverable if the attorney wants to protect it. The investigations that your forensic consultant performs should be thorough and proactive, and make sure nothing is missed. Generally, you cannot go back and add more issues to the claim at a later time. Builders and their insurance carriers, who often fund the settlements in these cases, will typically demand a full release of all claims, whether known or unknown, present or future, in exchange for a monetary payment. So this is, a one-shot deal, generally, defect litigation, and so it's critically important to have a thorough investigation. Again, the warranty program and the third parties that handle those warranty programs are typically not going to conduct this type of a thorough investigation that your independent consultant will perform. Next thing we're going to talk about is a legal term, standing. The term standing refers to the party that has the right to bring a claim, or the party that has suffered the damages as a result of a construction defect. And in terms of a claim for a homeowners association, typically what we're talking about is, does the HOA or the homeowners association itself have standing to bring the claim, or do the homeowners need to bring the claim? So under the SB 800 statute, HOAs and individual homeowners have standing to pursue claims for construction defects, depending on the nature of the defect. Representative standing may also be available for construction defects. Representative standing is similar to a class action, where a homeowners association could bring a claim on behalf of the members of the community. But there was a recent case that came out from the appellate court that holds that an HOA cannot pursue claims under the Right to Repair Act, commonly referred to as SB 800, except if the HOA has standing under the Civil Code, as we will discuss in the next slide. So representative claims are not available for SB 800 claims, but non-SB 800 claims, representative standing still is available. If representative standing is available, the HOA can bring the claim for individual homeowners and members, even if they do not relate to common areas. The Civil Code provides the HOA with standing to bring a claim without joining the individual homeowners in the process, as long as the claim relates to damage to the common area or damage to a separate interest that the HOA is required to maintain or repair, or damage to a separate interest arising out of or integrally related to damage to common area or a separate interest the HOA is required to maintain or repair. Separate interest, what we're referring to here is property owned by the homeowners as opposed to the HOA. So in a condo building, for instance, typically the interior components of the units are separate interest property. A good example maybe is the internal plumbing components, sinks, for instance, shower stalls. Those components in a condominium are typically the separate interest property of the homeowners. In a planned development where the homes are standalone, single-family style homes, the homeowners typically own the entire home, the exterior and interior, and therefore the residence is the separate interest. In order to determine what is a common area and or an HOA maintenance responsibility, a careful review of the covenants, conditions, and restrictions, what we refer to as the CC&Rs, will be required. The CC&Rs are not always clear, and sometimes there are conflicts between certain provisions in the CC&Rs as to what is common area and or what is an HOA maintenance responsibility. So oftentimes it's important to consult with your legal counsel so that they can evaluate, in fact, whether certain components are common area or an HOA maintenance responsibility, such that the association would have standing to bring the claim. Next thing we're going to talk about is SB 800, or the Right to Repair Act. SB 800 stands for Senate Bill 800, which went into effect for all residential homes constructed in California after 2003. This is also known as the Right to Repair Act. SB 800 significantly changed how defect claims were handled in the state of California. Prior to the enactment of SB 800, construction defect claims could only be pursued if the defects had actually caused damage. So, for example, if a building was not constructed in compliance with the building code related to a fire safety issue, for instance, a claim could not be brought until a fire occurred and caused damage as a result of the defective construction. So that doesn't make a lot of sense if the building was not constructed according to the building code for fire safety, that you should have to wait until an actual fire occurs to seek a remedy. And so that's one of the things that SB 800 was designed to resolve. So now damage is not required, and buildings must be constructed in accordance with what's called the functionality standards that are listed in the statute. SB 800 also provides a procedure designed to resolve defect claims without litigation, which includes sharing information about the claims, site inspections and testing, mediation designed to resolve the claim, and the right for a builder to implement repairs even over the objection of the homeowner. I'm going to talk about this process in detail on the subsequent slides. So as I mentioned, under SB 800, there are what are called functionality standards. So the statute itself lists numerous components of construction, for example, windows, doors, decks, roofs, plumbing, etc., and describes how these components should function. One example is the statute provides that windows shall not leak, and roofing materials shall be installed such that they do not fall from the roofs. And if these standards are violated, then an HOA or homeowner, depending on who has standing, may bring a claim to have the SB 800 violations repaired or for money to make the repairs. As a result, not every conceivable defect is listed. Therefore, there is a catch-all provision in the statute that provides if a component is not addressed, then a claim can only be pursued if the defect actually causes damage. And that is essentially what the law was prior to the enactment of SB 800. The cost of the repair is recoverable in a defect claim, in addition to the cost to investigate the claim. And this can be very expensive, especially in larger communities. So it's important that the forensic investigation that is performed to identify hidden deficiencies or latent defects, like we talked about earlier, and to develop a scope and cost of repair plan, those expenses are all recoverable in these claims. In addition, you may recover cost of relocation expense or lost business income if the residence or any of the residences in the claim were used as a business. In addition, there are recoverable costs under the law or contract that can include attorney's fees if provided in a contract, for instance, purchase and sale agreement or the CC&Rs. But generally, those contracts do not provide for recovery of attorney's fees, so attorney's fees are often not recoverable in these cases. So the SB 800 claim process, the statutory language provides a default process, but you should also look at your CC&Rs or your purchase and sale agreements because they may modify the default process. The builders can have their own contractual procedures as well, and sometimes they do that. Oftentimes, they just defer to the default process. So the way the SB 800 claim process works is it is initiated by serving what's called a notice of claim. And the notice of claim essentially identifies all of the deficiencies, the violations of the functionality standards that are known at the project, and that is served on the builder, developer to put them on notice that you have a claim, and it starts the process. An important feature of the service of the notice of claim is that it tolls the statute of limitations. In other words, it stops the clock so that you can avoid the time bar by initiating a claim. It's essentially the same as, has the same effect, more or less, as filing a lawsuit within the time frame. So it's important to initiate the SB 800 claim process in a timely fashion. The process generally involves inspections and testing of the deficiencies. The developer is involved in that. They have their own consultants involved in that, and their own attorneys generally. There's an exchange of documents that occurs. So all of the relevant construction documents, the plans, drawings, subcontracts, contracts, daily reports are produced as part of the process. And the homeowners or homeowners associations may also produce maintenance records or logs of complaints from homeowners related to certain deficiencies. In addition, there is often an exchange of expert reports that are developed as part of the process. What's critically important is these reports are generally protected under what's known as the mediation privilege, meaning they're designed to resolve the claim or settle the claim. So they are considered a settlement communication. And why this is important is because it allows a free flow exchange of information between the experts and the attorneys involved in the case without the fear that if the claim doesn't resolve, it can be later used in litigation, and parties can be questioned in deposition or at trial about the reports unless they're protected under the mediation privilege. And why we don't want these reports to be discoverable early on is because early on the investigations aren't complete and the experts may change their opinions at a later time. And so they don't want to be challenged sometime downstream that their opinions have changed. So the mediation privilege allows, again, for the free flowing of information, exchange of information that is necessary to resolve these claims without anybody being fearful that later on it's going to be come and used against them. In addition, oftentimes there will be joint expert meetings that occur in this process where the experts can discuss their various opinions and try and reach some type of a consensus. And there is also a process whereby the parties can engage in mediation with a mediator to try to resolve the claim. Mediators are typically facilitators of the negotiation. They don't make decisions. They're not like a judge or an arbitrator. They kind of work with both sides and try and come up with a compromise to resolve the claim. If mediation is unsuccessful, the builders have a right to repair, regardless of whether or not the homeowners or the homeowners association agree that the builder's repair will rectify the problem. Builders still, under the law, have the right to implement those repairs over the homeowner's objection, and then the homeowners can pursue a claim for inadequate repairs, as well as a claim for any components that weren't repaired in that process. Generally, this SB 800 claim process can take about 6 to 12 months, depending on the size and complexity of the community and the issues in the claim. So what happens if the claim is not resolved in the SB 800 process? At that point, the HOA or homeowner may initiate a lawsuit in Superior Court or may be bound to pursue the claim in arbitration. Many CC&Rs provide for arbitration of these types of disputes. In arbitration, a service provider for a fee will provide an arbitrator to hear evidence and issue an award. Arbitrators are typically retired judges or seasoned attorneys. The arbitration award ultimately can be enforced by a judge in the Superior Court. Many CC&R provisions also provide that a vote is required by the membership before pursuing a claim. However, recent legislation was enacted finding that these provisions are invalid as a matter of law as they are self-serving provisions that are designed really to make it more difficult to pursue a claim for construction defects. Anybody that's ever tried to hold a vote in a HOA often can find that it's frustrating that people don't participate. There's unfortunately a lot of apathy sometimes out there, and people don't pay attention to their mail and they don't vote. And so it's not that they don't support the claim, it's just that they don't participate, they don't get the mail, they don't know what to do, they don't submit their vote. So again, these types of provisions are invalid, and you don't need a membership vote. It's a decision. The board members are the ones that can make a decision to pursue a claim on behalf of the HOA, and they were elected by the membership to make decisions such as those. Even though you don't resolve the claim in the SB 800 process and you have to initiate litigation or arbitration, it doesn't mean that the claim isn't going to settle. Most of these claims do settle, so even if the case proceeds to formal litigation or arbitration, the parties always can agree to go back to mediation, and they often do, sometimes multiple mediations, to try and resolve the dispute. And again, this is how most of these claims are resolved. So SB 800 does not apply to all claims. Older communities that had repairs or maintenance work done that resulted in defects are not subject to SB 800. Also, commercial condominiums are not subject to SB 800. It only applies to residential communities. So in those cases, the SB 800 functionality standards do not apply, and damage is required in order to pursue a defect claim. Traditional negligence, warranty claims, implied warranty claims, nuisance claims are all available in these cases to pursue construction defects. So although SB 800 does not apply, the process for resolving these claims is similar, as most attorneys that handle these claims are familiar with the SB 800 procedure, and that process is effective in resolving these types of claims. So oftentimes what happens is attorneys, even though SB 800 doesn't apply, they'll stipulate to follow a process similar to the SB 800 process that has all the features we discussed earlier. However, in these cases, there is no absolute right to repair afforded the builder. So that's kind of one of the unique things that in these types of claims, even though we may follow the same type of a process through mediation, the developer doesn't have the right to implement repairs over the objection of the homeowners or the HOA. So let's talk about some of the defenses to construction defect claims. The number one thing and the most important thing to be mindful of is the statute of limitations defense. There are deadlines to bring claims, and if they are not brought timely, they are forever barred. The HOA or homeowner must initiate SB 800 or file suit before the deadline expires. The absolute outside time frame to bring a claim for construction defects is 10 years from completion. However, there are shorter timelines for some of the SB 800 functionality standards, which can be very short. So for example, noise transmission between units in a multi-unit condominium, for example, is only 1 year from the occupancy of the adjacent unit. So those claims, typically it's pretty hard to bring those claims because they just have such a short time frame. And by the time somebody believes that a claim should be brought, oftentimes you're beyond the deadline. There's also 2, 4, and 5 year deadlines for other components. However, the most significant claims, for example, water intrusion through the exterior of the building, is generally subject to the 10-year statute. However, there may be a shorter period that applies to those claims, including the 3-year statute of limitations based on when the defect was discovered. There is some debate as to whether the 3-year statute applies to SB 800 claims, but in our opinion, HOAs and homeowners should not wait more than 3 years from discovery to bring a claim in order to be safe. So what that means is even though you might have 10 years from completion to bring a claim for leaking windows, once you know your windows are leaking, you should really bring a claim within 3 years of discovery of that deficiency. Otherwise, there's a potential you could be barred by the 3-year. There's also a defense for lack of maintenance. SB 800 provides that a failure to follow the developer's maintenance recommendations is a defense to a defect claim. Therefore, it is important to review the developer maintenance manual if there is one, or if it's not available, take a look at the developer reserve budget and follow the recommended maintenance procedures, or retain a construction professional to develop and implement a maintenance plan for your community. The reserve budget should generally have money set aside to perform the recommended maintenance. However, more and more we're finding that developers' maintenance manuals have extensive maintenance obligations that may be more aggressive than is really necessary, and the budgets that the developers prepare initially do not set aside enough money, in fact, to implement the maintenance that they recommend in their maintenance manual. So that's something to analyze, and you should engage your own construction consultant to assist in developing a proper maintenance schedule and plan that you can implement and follow. And if there's not enough money in the budget to perform the recommended maintenance, then the board should consider possibly an increase to make sure that proper maintenance is being performed and also documented, so that if there is a defect claim, you have evidence to support the fact that you did follow the maintenance requirements. So some of the tools to identify deficiencies and protect the value of your communities. What should you do to protect against construction defects? Number one, you should hire professional forensic construction consultants, typically through your attorneys. But if not, at least have a consultant inspect your community and investigate for latent defects or conditions that they believe may be concealing deficiencies and damage. And make sure you bring a claim before the statute runs if significant defects are in fact discovered. Two, perform regular required routine maintenance to make sure the buildings perform as intended and you do not subject yourself to a lack of maintenance defense, as we just talked about, if there are defects. Three, make sure when you do hire contractors to perform repairs, or maintenance, make sure that they're competent and qualified to perform the maintenance and repair work that they're being hired to perform. Make sure that the contractors that you do use have adequate insurance in case there are defects discovered, and their contract should also include a provision requiring the contractor to defend and indemnify the homeowners association for any damages resulting from their work. Your attorney should review the contracts to make sure that this language is included. So that brings us to our conclusions and key takeaways. The most important thing in all of this is to make sure that you bring a timely claim. That means you have to have a professional forensic evaluation performed for not only known or suspected deficiencies, but hidden latent defects, most critically, and get that done before the statute of limitation expires. Make sure you rely on independent professionals. Do not rely on the builder or their contracted third-party inspectors or warranty companies. Have your own attorneys, property managers, and construction consultants assist you and evaluate your community and advise you on whether you have a claim that should be pursued. So with that, we are concluded. Thank you.